Today we are most delighted to have Pam Karlan with us. She is the Kenneth and Harley Montgomery Professor of Public Interest Law at Stanford Law School, one of the world's experts on a number of areas of constitutional law, in particular voting rights. She and a couple of her colleagues literally invented the field of the law of, or the study of the law of democracy. Sam Zakharoff and Rick Pildust, and she have the best book on that topic. She's a prodigious contributor to public interest causes of all sorts and finds a way in the midst of all of that activity to maintain an incredibly productive scholarly life as well. She is clerk for Judges Sofair and Justice Blackmun on the Supreme Court and is the founding director of the Supreme Court Litigation Clinic at Stanford, which I just learned this year has 6 cases before the court for argument. She's sort of set the model for a Supreme Court litigation clinic and then set the bar much too high for any other school to ever equal. She's also a frequent contributor to public commentary on public law issues, both in radio and television, frequent contributor on the Lair Hour, especially around the times when the court is ending its term in late June, when she'll often be on for a series of evenings as the court rolls out controversial opinions, and she's in discussions frequently with Doug Kamek. So much so that one day a friend of mine, after watching the Lair Hour, came up afterwards and said, "Where was Pam? She wasn't on that particular evening." Well, she's here today for us to talk about voting rights, and we're delighted to have her.
Well, thanks so much, Chris. It's really a pleasure to be back here at Duke, and I you know, when somebody gives you such a nice introduction, you don't want to correct anything about it, but in the audience today is Dick Engstrom, who taught me most of what I first knew about voting rights. So if I invented the field, that means he must be like Australopithecus of voting rights. So anyway, it's a pleasure to be here, and it's especially a pleasure to be here on Halloween, because I think the lessons learned from the Bush administration and thinking forward about voting rights, it really is trick or treat. In some sense, it's not perhaps surprising that the Bush administration has shown such disdain for protecting voting rights. After all, President Bush was elected due to a series of voting rights failures. You all know about the butterfly ballot in Palm Beach. But actually, I think there was a bigger failure that dwarfed the butterfly ballot, or dwarfed the undercount, or dwarfed the pregnant chads that never gave birth, and the hanging chads, and the dimpled chads that never smiled, and the like. And that was Florida's lifetime disenfranchisement of people convicted of a felony. Florida, at the time of Bush against Gore, disenfranchised roughly 600,000 individuals who had finished serving their sentences. Among them, roughly 10% of the state's African-American population. And you all know that the margin of victory, the official margin of victory in Bush against Gore, was 537 votes in Florida. But Chris Uggan and Jeff Manza, who are sociologists at Northwestern, have estimated that if ex-offenders who had completed serving their sentences had been allowed to vote, and had voted only at the same rate as other people of their same socioeconomic background, age, and the like, Al Gore would have carried Florida by more than 31,000 votes. So voting rights makes a difference. But Florida's law was actually even worse than that. You don't have to engage in counterfactual hypotheticals or try to do mathematical modeling to see how felon disenfranchisement laws distorted the 2000 election and may continue to distort elections going forward. Because Florida didn't just exclude ex-offenders from the polls. They excluded people whose names matched the names of ex-offenders from the polls. And so they ended up with thousands of eligible voters who showed up to vote and were told they couldn't vote because of these laws. Statewide, after the election in Florida, about 4,800 people appealed their exclusion from the voting rolls, and 2,400 of those 4,800 people were restored to the list as eligible voters. So it's no surprise, given how things started out, that they went swiftly downhill in the Bush administration. The stage was set for, I think, what we've experienced over the last 8 years. And in my talk today, I want to talk and examine both what I think of as a conceptual lesson that's come out of the last 8 years about the right to vote and what it means, and then talk about an enforcement lesson that's come out of the last 8 years. So a little bit of substance, a little bit of procedure in that sense, right? Because everything in law is either substance or procedure or both. And then make some suggestions about how to go forward from here. Now, the intellectual starting point on the substance of voting, what's the right to vote mean, is the first major voting-related statute passed during the Bush administration, the so-called Help America Vote Act. And I say so-called because I think of the Help America Vote Act being to helping Americans vote what the USA Patriot Act is to being a patriotic American, which is not something all that close. Now, the act started out as a reaction to the debacle of 2000 election. But in the end, it's done very little to guarantee a new right to vote, and it's sown a lot of confusion along the way. Part of this is because the act seeks to perpetuate the idea of matching voters on the voting rolls to various other lists that are maintained by the government. But it turns out that those lists are often quite inaccurately maintained. And so requiring a match means knocking people off the rolls. And so every day, if you've been following these things, I imagine many of you go to something like 538.org and you're constantly clicking refresh to see have states changed colors in the last 12 minutes and the like. But you can also go to a wonderful election site that's run by the law school at Ohio State called Election at Moritz. And they have a running list of all the litigation going on around the country. And we're seeing huge amounts of litigation to try and deal with exactly the problems we had in 2000, now in 2008. Now, why is that? Because we didn't fix the problems, and instead we passed a statute that actually exacerbates some of those problems. But at the same time, one of the things that was part of the dynamic, and Chris wants me mostly to talk about administration and the executive branch and not talk so much about the courts, so I won't be talking very much about the courts. I'll be talking about how the administration has treated voting rights. And one of the things that the administration did very quickly is to start trying to elevate concerns about voter fraud over concerns about voter exclusion in arguing about the integrity of the election process. And so what they have done is to suggest again and again and again in a variety of ways that vote fraud is the real problem that plagues American democracy, not the exclusion of people who are eligible to vote from the polls. And this is a real problem, and I'll just give you one example from my own practice, which is I worked on a voter ID case from Indiana that was decided by the Supreme Court last year, a case called Crawford against Marion County Board of Elections. Indiana promulgated one of the most draconian voter ID laws in the country, and the Bush administration supported that law. Now, the law required you to have a valid state or federally issued ID with your picture on it to cast a vote in Indiana. And there are thousands of people in Indiana who don't have these IDs. And what was the ostensible reason for the law? You cannot pass a law and say, we're passing this law to make it harder for people to vote. So they said, we're passing this law to avoid in-person vote fraud. That is, people coming to the polls and claiming to be somebody other than who they are. So in discovery, we asked the state of Indiana, since 1837, which is, I believe, when Indiana became a state, how many examples of in-person vote fraud have there been? And the answer was 0. They couldn't point to any. Now, lest you think that should be dispositive in its own sense, several commenters and supporters of their side have suggested that's just a sign of how successful vote fraud is, that you don't know it's happened. Which is a kind of heads you lose, tails I win, it's a breath mint, it's a candy mint theory of, or I guess now that Tina Fey is on Saturday Night Live, we should say it's a floor wax, it's a dessert topping theory. And so this idea that fraud is the major problem with our system, not that people don't participate who should be allowed to participate, that people are participating who shouldn't, is one of the central intellectual messages of the Bush administration. And I think this is a serious, serious problem. Because until we change our understanding of what the right to vote is about and what the dangers and real threats to the right to vote are, it's very hard to move forward. Now, the major place where the executive branch itself enforces voting rights is in the Department of Justice under Section 5 of the Voting Rights Act. Section 5 of the Voting Rights Act essentially provides that in certain covered jurisdictions, and 34 counties in North Carolina are covered, but most of the Deep South is covered, lots of the Southwest is covered, Alaska is covered, 3 boroughs of New York City are covered. These are areas which had used literacy tests to qualify people for voting, and which voting levels were depressed as of either 1964, 1968, or 1972. In these so-called covered jurisdictions, before you make any change in election law, no matter how small, you have to get federal approval for the change. And federal approval is supposed to be conditioned on whether the change that's being made makes minority voters better off, makes them worse off, or leaves them the same. And the federal government cannot approve a voting change that makes minority voters worse off. But the administration, over the last 8 years, has pre-cleared, has approved a number of very dubious laws, and I want to just focus on 2 of these. The first of these is voter ID laws, because these laws were passed not just in Indiana, which isn't a covered state, but have also been passed in covered jurisdictions like Arizona and Georgia. And both times, the professional staff, the career employees at the Department of Justice, unanimously recommended that these laws be objected to, because these laws have a disproportionate impact on minority voters. 1/3 of black men between the ages of 18 and 30 in Georgia do not have driver's licenses, which are the most common form of photo ID. Blacks and Latinos tend to be less well off than whites, so they tend to be less likely to own automobiles and therefore less likely to want to get driver's licenses. They tend to be less likely to have the resources to travel abroad, so they're less likely to have passports. In Arizona, many older Latinos were born at home, and so they don't even have access to a birth certificate. So these laws have a disproportionate impact. And I want to bracket that for a moment and just make one other observation, which is not about race here, but is about the fact that these laws also have disproportionate impacts on the elderly, who tend, even if they have ID, sometimes to let the ID lapse. Right? My grandmother kept her driver's license until she died, but it's a good thing that she gave up driving around the time she was 70, because the last 20 years of her life, if she had been driving, there wouldn't have been a last 20 years of her life. And you know that old saying, I want to die like my grandmother died, asleep on a beautiful day with not a care in her head and not the way her passengers went. Elderly people often don't keep valid ID. Disabled people often don't have voter ID. Urban people are less likely to have voter ID than people who live in rural or suburban areas, because they're less likely to drive. And when you add this all up, oddly enough, all of the legislators who have voted for voter ID bills practically have been Republican, and all of the legislators who voted against these laws have been Democratic. So there are not just racial consequences to these laws, there are also socioeconomic consequences and political consequences. And the Bush administration, despite the recommendations of all the career people at the Department of Justice, approved the Georgia law and approved the Arizona law, which have now both been in litigation for over a year. And the Supreme Court, with 2 new Bush appointees on it, approved the Indiana law, despite the fact that, as I said, Indiana was unable to point to a single example of in-person voter impersonation. And in the first election after the law went into effect, we now have on one side 0 false voters, and on the other side the famous 8 nuns of Indiana, which is not it's not a rock group. The 8 nuns from Indiana are 8 elderly retired nuns who continue to live in their convent. They want to go vote in the presidential primary. They go downstairs and over to the social center, which is a polling place. And they present their expired driver's licenses and passports and are told, no, I'm sorry, this isn't good enough. By a poll worker who is also a sister in the same order with them, and who knows them personally but says, rules are rules. raising the question whether that old idea that the Old Testament is about the law, but the New Testament is about the spirit and not the letter, doesn't apply in the secular world as well. So we have a kind of Old Testament interpretation of voter ID. So that's one example of this idea that laws that are really designed to deal with a non-existent problem are permitted to disenfranchise real voters. And some of you who've done First Amendment work will remember the famous statement, men feared witches and burned women. We now have fear of in-person voter impersonation, and we disenfranchise nuns. Second example I want to give you is about a different conception of the right to vote and how that conception has been distorted over the last 8 years. This is another lesson from the Bush administration, and this involves the so-called Texas redistricting. Most states redistrict every 10 years. And when a state can't agree because the government is controlled by different political parties, that's usually why a state can't agree. Like the governor is a Republican and the state legislature is Democratic or vice versa, or the two houses are divided. The redistricting often gets thrown into the courts, and the courts draw a plan. In 2001, Texas had divided government still, because although the governor and the state senate were Republican, the state house was Democratic. So they deadlocked, and a federal court drew a plan. But by 2002, the Republicans in that election took over both houses of the state legislature and announced they were going to redistrict the state to get what was theirs. And they managed to change a plan from a plan in which there were 21 Democratic representatives to one in which I think there were 11 or 12 by redrawing the lines. One of the things that you probably all know is we have a myth in America that every 2 years you go into a voting booth and pick your congressman. The reality is every 10 years, usually, your congressmen go into a booth and pick you. And so Texas decided it would redistrict. And one of the things it did was to shore up a district in South Texas that was electing a Hispanic Republican, Henry Bonilla, on the basis of the white votes in the district. That is only about 8% of the Latino voters in the district were voting for Henry Bonilla, but he managed to continue to be elected. But it was looking bad for him because the trend lines were more and more Latinos were voting, and Latinos were more and more opposed to him. And so his days were numbered. And so what the Republicans did is they carved up his district to give him a whole bunch of new white voters while separating the Hispanic voters into a district that I started calling the fajita district because it was very long and thin, like a strip of meat. And it ran from McAllen, which is right on the Mexico-US border, up to the suburbs of Austin, which is about 350 miles away. And it took in communities that really had no history of dealing with one another. So they redrew this district. And here's what's interesting, and I gather you're going to be seeing him in a couple of weeks, but Justice Kennedy, for the first time in his career on the Supreme Court, found a Voting Rights Act violation. Because he said, look what you've done. You've taken away, right at the moment at which Latinos were about to elect a candidate of their choice, you've jiggered the system to perpetuate their inability to elect. And he said this not only violates the Voting Rights Act, but the way he talked about it, he was suggesting this comes really close to an outright constitutional violation. That is, this was a racially discriminatory purpose. Now that's what the Supreme Court did, but the Bush administration had first crack at this district. And the Bush administration upheld this district in the pre-clearance process, said that Latino voters in South Texas were not being rendered worse off in any way. Again, over the unanimous recommendation of the career people at the Department of Justice. So substantively, what have we learned from the last 8 years? Well, one of the things we've learned is that we have a problem with the way we think about the right to vote. Almost all of the current statutory protections of the right to vote are phrased in the negative. That is, they're all about reasons you can't deny people the right to vote. They're not about the government's responsibility to give you an affirmative right to vote. So if you look at the right to vote in the Constitution, right, the 14th Amendment says you can't deny people the right to vote and still keep your electoral votes. And because if you deny people the right to vote on any ground other than their participation in a rebellion or a crime, you will lose some of your House seats. That is a provision that has never been applied. The 15th Amendment says you can't deny the right to vote on account of race. It doesn't say you have the right to vote. It just says if you have the right to vote, it can't be denied on account of race. The same thing with the 19th Amendment and gender. The same thing with the 24th Amendment and the poll tax. The same thing with the 26th Amendment and age. They all presuppose that the right to vote came from somewhere else and then just say, but you can't exclude certain groups from that right. They don't say anything about an affirmative vision of the right to vote. Again, no surprise that this administration doesn't care about that, because this administration got elected in part because the Supreme Court was able to say in Bush against Gore, no individual in the country, no individual citizen has a federal constitutional right to vote for electors unless and until the state legislature chooses to give them that right. Now, a negative conception of a constitutional right can work fairly well when you're talking about an issue, a right that involves the right to be left alone. The right to privacy, for example, can be vindicated in large part simply by telling the government to stay out of our bedrooms, or stay away from our email, or stay off our property. But a negative conception of a right doesn't work nearly as well when the ability to exercise the right depends on governmental action. A citizen who's handed an official ballot in a language she doesn't understand is effectively denied the right to vote. A citizen who lives in a county that uses antiquated election machines so that lines build up so long that she can't vote during her lunch hour doesn't really effectively have the right to vote. So if we're going to continue to have a system in which the government doesn't make the right to vote easy and available to people, we're not going to have a full right to vote. And I think we're going to see some of this lesson play out over the next week or so. If you want another website for you to go to My Fair Election. My Fair Election is a wiki in which there's a Google map of the United States, and people can write in and say, here's my polling place, and here's what problems I've had in that polling place recently. And there are already people up there saying, I showed up in Ohio to early vote, and I brought my voter registration postcard with me, and they say my name's not on the list, so I have to cast a provisional ballot. Now you might think, oh, that's not so bad because they'll fix this all later. One of the problems, though, is the HAVA Act, the act I was talking about earlier, the Help America Vote Act, says that the state has to give you a provisional ballot, but doesn't say it has to count the ballot. It leaves up to the states the decision about whether to count ballots. So what would it mean to develop an affirmative right to vote? It would mean saying that the state should treat the right to vote the way it treats other pieces of citizenship that it takes seriously. So let me just point to two: jury service and selective service. Right? With jury service, the state sends you a jury summons, and it sends you a prepaid mailer to send the summons back. And if you don't answer the summons, they come after you. They make a real effort to see that people will show up for jury service. And for selective service, the state, the federal government, makes selective service forms available in every post office in the country. And it conditions your eligibility for student loans for students who are obligated to register on your registering and like. So the government goes after people again. Now, in other countries, this happens. In our neighbor to the north, the one with the strong dollar, the government goes door to door registering people to vote. In other countries, people vote on holidays, or the government provides them free of charge the ID they need to vote. In most other Western democracies, there is no disenfranchisement of people who've been convicted of offenses. Sometimes they disenfranchise people who've been convicted of election offenses, but otherwise they don't. In Germany, they set up polling places in prisons. In Israel, the man who assassinated Prime Minister Rabin is eligible to vote. In Canada, prisoners vote. In South Africa, they vote. In the Netherlands, they vote. There are very few countries that don't do anything to try and reintegrate ex-offenders into civil society the way we do. So the reforms we've done so far haven't worked, but I want to point to a lesson from administration and the executive branch, which is we know that these laws can work, and I'll give you one example, which is right after the Voting Rights Act of 1965 was passed, one of the provisions in the act said that the federal government could have civil service workers go and register voters in the South. And in the 2 years after the act was passed, the Johnson administration sent federal civil service people south and used federal employees in the South to do this registration. and registered more African Americans than had been registered in the century since the 15th Amendment was passed, in 2 years. So we know it can be done if you have an administration that has the will to do things. So now let me turn to that procedural point, which is enforcement. Many of you, I am sure, have recently read the reports by the Department of Justice's Inspector General, Glenn Fine, concerning political firing and hiring at the Department of Justice. The titles of the reports themselves tell you a lot. One is called An Investigation of Allegations of Politicized Hiring in the Department of Justice Honors Program and the Summer Law Program. Then there was one about politicized hiring by the Office of the Attorney General. That's the Monica Goodling report. Finally, there was an investigation into the firing of 8 U.S. attorneys across the country. For me, one of the most striking things about these distressing reports is that we still don't know what exactly has gone on in the Civil Rights Division and in the voting section in particular, because the first report about politicized hiring says, and here I'm going to quote, "The issues concerning the Civil Rights Division's hiring practices are being examined in our separate investigation on the hiring, transfer, and case assignment decisions in the Civil Rights Division." It's as if things in the Civil Rights Division were so bad they need their own report. It is quite clear that things were very bad indeed. Now, I want to make a bipartisan point here, which is this is not about Republican departments of justice being inevitably worse on enforcing Voting Rights Act than Democratic departments or the like. Because many of the people who left, including Joe Rich, who I'm going to talk about in a moment, were people who were hired during the Nixon administration as career employees, who served in the Nixon administration, the Ford administration, the Carter administration, the Reagan administration, the George Herbert Walker Bush administration, and the Bill Clinton administration, but felt run out of the department by the George W. Bush administration. When I was in practice, for much of my time in practice, and this was when I got to know Dick, the Justice Department was under the leadership of John Dunn, who was the appointee of George Herbert Walker Bush. And he was quite easy to deal with. We didn't always agree with him, but no one doubted his commitment to enforcing the law as best he could. And no one doubted his respect for the career employees of the Department of Justice. And so what I want to turn to now is what we have learned about the career employees. Approximately 60% of the career staff of the voting section of the Department of Justice left during the Bush administration. And this is a group of people who bring an amazing wealth of experience and knowledge to the enforcement of the law, and in particular to the Department of Justice's special responsibilities under Section 5 of the Voting Rights Act. The department, for 5 of the 8 years of the Bush administration, brought no Voting Rights Act cases of its own. No, I shouldn't have said that. During that 5 years, they brought 1 Voting Rights Act case. That case was on behalf of white voters challenging their exclusion from the political process in a majority black town in Mississippi. But they brought no other cases. They pre-cleared things that would never have been pre-cleared in the past. They hired people who would never have been hired in the past, because in the past, career hiring into the Department of Justice in the Civil Rights Division was done by the career employees. They interviewed people for the honors program. They made recommendations, and those recommendations were almost always accepted by the political appointees in the front office. That changed dramatically during this administration. The other thing we learned is a number of the firings, of the unjustified firings of U.S. attorneys around the country were tied to concerns about election law. And mostly what they were about was the refusal. And remember, the people who made this refusal, the U.S. attorneys who were fired here, were not career employees of the Department of Justice. They were presidential appointees. These are people who were appointed because they were Republicans. And they determined, when they were asked to do investigations, that either the claims of vote fraud were invalid or that the investigation required more time before any public announcement could be made. And they were pressured, both by local Republican politicians and by the White House, to change their views and to make announcements during the campaign. And they said, the guidelines of the Department of Justice don't permit us to do this because we're not supposed to let investigations change the outcome or become part of the political argument of campaigns. And they were fired for this. So one of the lessons we have learned from this administration is that a politicized Department of Justice cannot perform its tasks fully and fairly. And so going forward, what do I think we need to do? Well, first we need legislation. And we should hope that the next administration, like the Johnson administration, drafts a bill to protect voting rights that actually moves the ball forward. We know how to do it. We know how to do it both because we've done it in some parts of the country for some periods of time in the past, and because other countries around the world do this. And so even if our courts shouldn't be looking at foreign law, surely our executive branch should be looking at foreign administration systems. One of the things that struck me most was about 3 or 4 years ago, the UN had a conference on voting in North and Central America. And I went to the conference. It was in Mexico City. There were no other U.S. folks at the conference, but there were folks from Canada and Mexico, Bolivia, Brazil, Argentina, not Argentina, but I'm trying to think. There were 7 countries there. Every one of the other countries has an election system that's run by nonpartisan government officials. Every one of those countries makes an affirmative effort to register people to vote. The Brazilians have developed a voting machine that you can put in a canoe and take up the Amazon that not only can people vote on, but it has an audit trail. So it can be done. Right? The Canadians do door-to-door registration. The Mexican government has developed an independent electoral tribunal to decide election disputes. So one of the lessons is it can be done. A second lesson is you have to fix these things before the election. Because once the election is ongoing, it's not only confusing, but it becomes so clear what the partisan valence of any particular decision is, that both the courts and the public know the outcome, know the result of the litigation, and that destroys everyone's faith in the integrity of the system. I think if you had asked the U.S. Supreme Court in the spring of 2000 how they would decide a hypothetical case like Bush against Gore, you would never have gotten the decision you got. But the temptation was too great at the end, both because the Republican justices on the Supreme Court thought the Democratic justices on the Florida Supreme Court were playing fast and loose with the rules, and because the Republican justices on the Supreme Court realized that all they had to do was choose from an array of conceivable outcomes one that would match their policy preferences. The second lesson going forward is, of course, it matters who enforces the law. We have never before this administration had so politicized a process of hiring career employees, supervising career employees, rewarding and punishing career employees as we've had over the last 8 years. And so the other lesson going forward is that we have to remake the Department of Justice into the department we had before the last 8 years. And that's the lesson of the Bush administration. Thank you very much. Questions or anything? Great.
Thanks very much, ma'am. We've got time for a few questions. Left you speechless. Yeah.
Sure. So there are 2 questions. One is the non-citizen voting, and the other is the dead people voting. The dead people voting actually can be fixed if you maintain up-to-date voter rolls. If the states actually worked a little harder on getting the computerized matches, for example, so that death certificates are sent to the states are all supposed to be developing centralized voting registries now. If you matched that against death certificates, that would do a lot of good. The other thing is when dead people vote, they tend to vote absentee. I mean, seriously, because most vote fraud in the country is committed through absentee voting, not through in-person impersonation at the polls. And the reason for this is you need a live body to go to the polls for vote fraud at the polls. And this runs you a couple of risks. One is many precincts in the country, there are many states in which the precincts have only a couple of hundred voters in them. So the risk, if I show up at the polls and I say, I'm Mother Teresa, I'm here to vote, or who's a famous dead woman, recent famous dead woman? Anybody got one for me? Eleanor Roosevelt. Well, by now they should have gotten her off the list. But if I show up and I say, I'm Eleanor Roosevelt, I'm here to vote, chances are somebody's going to hear me and say, you're not Eleanor Roosevelt, right? And I can't go back to the same poll and keep voting in different dead people's names, right? So it's actually kind of expensive to do fraud that way. Supreme Court pointed to an example of that kind of fraud in its Crawford case. The example was from the Boss Tweed era. It was from, I think it's the 1878 New York mayoral election, 1876, somewhere around there. Because that was when you didn't have another option. If you were going to commit fraud, then it had to be at the polls. Now, all the fraud that's done, and it's not clear that there's a huge amount of it, but all the fraud that's done is done through absentee voting. Right? So that's where you would look. You wouldn't pass voter ID laws for that. Now, the problem of non-citizens voting. It's not clear that this is really a problem empirically. Many of the non-citizens that they actually found who have voted were not people who were deliberately trying to violate the law, but they were misled by things that told them, now you've become a legal resident of the United States, you have all these duties and opportunities to participate, and they didn't understand one of them is not voting. Although, incidentally, historically in America, we did allow these people to vote. That is, in the 1800s, landed immigrants, people who had come to the United States, were often permitted to vote while they were becoming citizens. So it's not clear how much of a problem it is. But then the question is how you do the trade-off. Because like everything else, there's false positives and false negatives, right? And there's at least a little bit of a trade-off between these. That is, you could avoid allowing any dead person in the United States to vote and allowing any non-citizen to vote by making it really hard to vote. But then you would also end up excluding a lot of other folks. And so the question is, first of all, how much of a problem is this? And second, aren't there ways of doing this other than putting the burden on individual citizens to have a lot of ID documents? But you're absolutely right. There's nothing that's going to get rid of that problem completely, at least not at what I think of as an acceptable cost. Does that?
I'm just curious how expensive it would be. I mean, you say compare the death certificates, compare very accurately felons, convicted felons, to the voter registration to not cross off the same name who have never been convicted. And that just seems extremely expensive for a state to have to compare every felon and make sure that it's actually the person.
Right, but otherwise the result is, that, I don't know what your name is, but suppose your name was James Brown. Right? Your chances of being knocked off the list if people don't do any kind of attempt to make sure the matches are accurate are pretty high, because there are probably, 3,000 people named James Brown serving time somewhere in the U.S. now. Not to mention the famous James Brown is dead, right? And so that would cause you another problem. So it is expensive. Now, how do other countries solve this? The civil libertarians here aren't going to like this answer so much, but the way other countries solve this is they all have national IDs. And you just bring your national ID to vote. But those are all countries where the government provides you with a national ID. They're not countries where you have to get one. So let me just tell you very briefly the story of one of the people who was a witness, an affiant in the Indiana case. This is a woman who, I think she's about 80. She went to register to vote in Indiana when she moved there. And they said, you need to bring a copy of your birth certificate. Because she was trying to get the voter ID card. So she goes home, she gets her birth certificate, she brings it back. They look at it, they say, this is not good enough. This is not a certified copy of your birth certificate. So she was born in Massachusetts. She mails away. It costs her $29, I think it is, to get a certified birth certificate. It takes a couple of weeks. It comes back. She now goes back with her certified birth certificate. She shows them the birth certificate. And because this woman isn't Eleanor Roosevelt, this is because this woman isn't Eleanor Roosevelt that this is about to happen, and you'll see why in a moment. So they look at the birth certificate and say, this is not good enough. She She says, why? They say, this doesn't have your name on it. Now, why did it not have her name on it? Because unlike Eleanor Roosevelt, her name wasn't Roosevelt before she married somebody named Roosevelt. Right? Eleanor Roosevelt is the only person probably in the whole country who wouldn't have this problem of married women who are 80 years old. Because married women who are 80 years old, almost all of them took their husband's name. Their birth certificate, since we don't believe in child marriage in the United States, doesn't have their husband's name on it. So now they say, go and get a certified copy of your marriage certificate. Okay, now here's the problem. This is a woman who really does want to vote. But if you make it this hard and this difficult, especially given something we know, which is actuarially, you are more likely to be killed driving to the polls on election day than to cast a decisive vote in a particular election. So you've got to really be devoted to the idea. Right? There are more traffic fatalities on the road on election day. I mean, we don't know. Maybe these people weren't going to drive to vote. Maybe they were all going to drive to go get lottery tickets, in which case aren't they unlucky? But, you know, if you make it really hard for people, people will drop out of the process. And it won't be random who's dropping out of the process. It will be the people with the least resources to get the stuff. I mean, everybody in this room, I dare say, right now has valid photo-issued government ID. Probably most of you have a passport. All of you probably, you know, once you've got that stuff, you can keep getting it. But you know, to those who don't yet have, not much is given. And so it's very hard under those circumstances. So the question is, who's going to bear that cost? And I think if we had an affirmative notion of the right to vote, we might think about it where the burden of proof should lie, and like quite differently than we've done.
Charlie. So could we be more like Canada if the federal government did all this, and would that be legal? I mean, constitutional? Is that a possibility?
So two answers to this. Would we be better off? We might be, or we could have what we tend to have, which is just kind of cooperative federalism, where the federal government sets some standards and gives the stuff to the states and has them do it. Would it be constitutional? Yes, and there are two reasons it would be constitutional. One, which is a kind of practical, cheap and dirty way of doing this, is you simply set the standards and the like for any election that's what we call an Article 1, Section 4 election, which is any election for the House of Representatives and now also for the Senate, which is Congress has plenary power over those elections. And that means any election on which a candidate appears on the ballot. So what the federal government's done in a couple of these statutes, like the Motor Voter Act, is to simply say, in any election involving a federal candidate, you have to do these things. And it's so expensive for the states to maintain dual systems that they then run that system both for the federal elections and for the state elections. So that's the quick and dirty way of doing it. The slightly less quick and dirty way is to claim that you're doing it under the enforcement power of Section 5 of the 14th Amendment, which is to say that the right to vote is a fundamental liberty interest, or that there are serious equal protection questions about the right to vote, because it actually has been treated as kind of fundamental equal protection. You get this kind of weird strict scrutiny fundamental rights equal protection. Don't worry about this if you haven't heard this, because this is the only place where it actually occurs. But the result of that is that Congress has special enforcement powers to enforce the right to vote under the 14th Amendment. And you might claim that what they're doing here is trying to equalize the field, and therefore it's appropriate use of their enforcement power against the states. But you certainly can use the Article 1, Section 4 thing if worse comes to worse, and that'll get you 99% of what you want to have.
So I'm thinking about what you said, how it's important to have this decided before Election Day. And I think that makes a lot of sense for the reasons you gave. But I see some problems with that. Like the first would be that certainly you can't bring an as-applied challenge until something bad has happened to you because you don't have any standing. The second would be, you know, if it's not going to be judicial, it's going to be administrative or executive or something like that. You know, how do you have the adverse parties who have the incentive to bring the claim? And then the third thing is, if that does exist, you know, I think you end up in a situation like we had, you know, in Florida with the butterfly ballot, where the parties had the chance to say no to the ballot, and the Democratic Party person looked at the ballot and said, "This is fine," and like kind of waived their opportunity to object. So how do we deal with that and still be able to handle these problems before Election Day?
Well, you know, you've identified something which raises, there are several different problems out there. One is, do we know what the rules actually are? And one of the problems we have is there's litigation over just what the rules are. It's not litigation about whether some particular person should be treated in a way. But, for example, we don't yet know in many states what is the actual rule for whether provisional ballots will be cast or not. That stuff should be done long before an election. The voter rolls should be cleaned up and maintained long before an election so that everybody has an opportunity to find out, am I on the voting rolls? Will I be allowed to vote? Now, if you're not on the rolls, then of course there are going to have to be individuals at that point coming in and saying, and either in an administrative or a judicial process saying, I'm not on the rolls and I should be. So it's not that you would get rid of all litigation. It's that the rules themselves should be set in advance of a particular election. You shouldn't have, I mean, this is one place where the Supreme Court, in some sense, was right in Bush against Gore, although they were applying it wrong, which is the rules should not be changing during an election because everybody should understand ahead of time. And if we had all known a year in advance that these were the kinds of matching that were going to be required, then the political parties can decide, are they going to make an effort to get these people matched properly? Are they going to file actions at a time when they actually can be adjudicated by judges who don't have the election breathing down their neck? You want to push as much of this stuff as far forward as possible, recognizing you're not going to be able to get rid of all of it. But the rate of election litigation in this country has skyrocketed over the last eight years. There didn't used to be as much litigation. And some of that is we have now a series of rules that are constantly changing and that are not clear. I mean, this is a place where rules versus standards is actually kind of helpful. Right? If the things are clear about what you need to do, then you don't have to worry about different interpretations by different boards. So, for example, there was litigation in the last month or two in Indiana because some counties were allowing early voting and some counties weren't because there was no requirement of uniformity. So in places where the county thought, the people who were in charge of the county thought that their party was going to have more people voting early, they voted for it. And in places where they thought it was the other party that was going to be getting out of the vote, they voted against it. All that kind of thing can be solved ahead of time. But you're right, that you're never going to get rid of all of the litigation. You just want to push as much of it as far forward as possible.
So say a word about vote suppression.
Yeah.
Either the kind of palm card that says Republicans should vote on November 4th and Democrats on November 5th, or the ones that say, if you want to come to the polls, be aware the list will be checked against the police records, and if you've got outstanding warrants, you probably should.
If you've got outstanding parking tickets.
Or parking tickets, you better settle them up.
Yeah.
I'd take it that the department's been less interested in vote suppression cases. At the same time, it's been more interested in voter fraud.
Yeah, they have been mostly interested in vote fraud and not in vote suppression. And I think that's a kind of fundamental change in the last 8 years. That is, if you go back to administrations before that, they seemed equally concerned with vote suppression. We don't have very clear laws on that either. I mean, we don't actually have an act. We have an act, Section 42 U.S.C. 1971, that says you can't threaten or intimidate somebody. It's almost never been applied. But it's not clear whether saying to somebody, Republicans vote on Tuesday, Democrats vote on Wednesday, falls within that. There's not a kind of misleading vote practices law. And that might be something to think about, is legislation to say, it's a criminal offense to tell somebody, to knowingly and deliberately tell somebody something false about election law for the purpose of leading them not to vote or to vote some particular way or another. The one law we've got out there now is a law that says you can't give somebody anything of value, either to encourage them to vote or not to encourage them to vote. Last election, I was contacted by some political scientists at Stanford. They wanted to give people rewards for doing something that related to their voting. I thought, don't do that because, 18 U.S.C. 497 or 491 or whatever it is. But we don't have a law that actually deals with vote suppression simpliciter. Now, if you tried to suppress people's votes because they were black, and you could prove state action, maybe you could bring a claim under the Voting Rights Act, but we don't have a general protection.
Yes.
You mean the voter ID law? Well, we don't know yet, right? Because we don't know how many people will show up at the polls on election day without sufficient ID. And then we don't know, of those people, how many of them are people who have the ID but just didn't bring it with them, and how many of those people will be willing, under the Indiana law, what happens is if you show up at the polls on election day and you don't have ID that's satisfactory, you can cast a provisional ballot, and then I think you have 10 days to go to the county courthouse with your ID, at which point if you provide the ID, they will then count your vote. So we don't know, how many people. Because it's very hard to know, for example, you can make estimates about how many people don't have the ID, but there's no way, actually one of my colleagues who's an empirical law and social science guy, was trying to figure this out. And states don't even maintain their records in a way that would allow you to match the people who lack IDs. Georgia actually put together a list of the people who lack IDs, but it's unwilling to release that list up against the lists of registered voters in a way that would enable you to figure out how many of the people who lack IDs are already registered to vote. How many of them turn out would be yet another thing you'd have to add on top of that. And then how many of the ones who turn out and are denied the right to vote and cast provisional ballots are subsequently able to satisfy the requirements. So it's hard to know.
Sunny?
What is the current status of law with respect to the time that polling stations are open? So I'm particularly interested, we're going to have lots of people come to the polls. If somebody's in line at the time the polling station was initially going to be closed, does that person have a right to vote? Do they have to keep the polls open for that person who's in line at that time to vote?
It's in each state, it's a matter of state law what they do. They are supposed to keep the polls open for people who are already in line, but in some states, those people are all forced to cast provisional ballots because they didn't get into the poll during the actual election time. Then there's a complication on top of that, which is if there's a state that's a covered jurisdiction under the Voting Rights Act that hasn't yet set a rule on that, if they try to change the rule in any way on election day, they have to get emergency preclearance from the Department of Justice. Yeah, and it's done state by state. And what hours the polls are open are state by state as well. So some states have longer periods to vote. We just got this at Stanford. We just got notified that there will be one polling place on campus, and all 3 precincts on the campus are going to vote in one polling place. And the county is. This is just unbelievable. But the county is taking the position that. Although all of these people are registered to vote at Stanford, since many of these people aren't permanent, full-time, year-round residents of Stanford, they don't need more polling places. Although, of course, the election is taking place during the semester, and they know how many registered voters there were. When I went to vote in the primary, they had all 3 precincts voting in the same place. There was no line out. There was no sign outside that told you there were 3 precincts. And the result of this is there was a huge long line for the undergraduate housing precinct. There was no line for the faculty precinct, but you had to stay in line for 30 minutes to get inside the room to find out there was no line. It was 10 a.m. in the morning when I got inside. They had run out of ballots already. They were giving people ballots in foreign languages because Santa Clara County is a 203 jurisdiction. So they said, if you feel like, are you here just to vote for the presidential? I mean, they were trying their best to be helpful. So are you here just to vote in the presidential election? Well, here, vote in Vietnamese, vote in Tagalog. Vote in Spanish. Well, the Spanish was pretty easy, but the other one's not so easy. And they were on the phone saying, could you send us some more ballots? Right, this is 10 a.m. in the morning. So now they're doing this blitz campaign to try and get everybody to vote absentee or to bring an absentee ballot to the polls with them, because otherwise they're worried that 8 p.m. will come and there'll be people who've been in line for hours and hours and hours. It was really inspirational in 1994 to see people standing out in the hot sun in South Africa to vote, and they stood in line for like 5 or 6 hours in the first post-apartheid election. That was really inspiring. It is not inspiring to see Americans standing in line for 4 or 5 hours to vote. But it's state by state.
One more.
Why do we not hold elections on weekends or have a national holiday? It seems like such an obvious fix to a lot of people. I'm just wondering what the history is.
You know, Jack Rakoff wrote a really short, interesting piece, the message of which I can no longer remember, about why it was we picked Tuesdays. But there was a reason that we picked Tuesday, and I don't know what it was. Did you?
People were doing harvesting on Saturday. Sunday they had to go to church. It took them a day to get to the county seat. Monday, so Tuesday.
Okay, well, so not so true anymore. Now the question about the question about would we be better off having a holiday is a difficult question in a way, as opposed to saying, vote on Saturday or have a 3-day voting period or like. And the reason having a holiday is a hard question is look at what happens on most American holidays, right? Which is, how do you get people to work the polls on a holiday? Because they're being told now it's a holiday rather than what often happens, which is they're allowed time off from work to work on polls. People go away on holidays. On Labor Day, does anybody really think about the laboring man anymore? No. On Memorial Day, how many people actually remember what Memorial Day is a memorial to? Veterans Day is like a day to go shopping. Martin Luther King holiday, most people don't even think about Martin Luther King, even though it's a more recent holiday. And so I'm not sure that a holiday does what you want so much as, for example, things like where Texas has moved with the idea that there's like a 2-week voting period and you set up polls. The other thing that works really nicely with those is a lot of those things, the government, and this goes back to my point about affirmative versus negative rights, the government takes responsibility in those circumstances in early voting places to figure out which ballot to give you. So you don't have to worry about getting to the right precinct because you just show up, for example, if I go down to the Santa Clara County registrar and show up on for early voting, they figure out which ballot I should get. Whereas if I show up at a precinct and it's the wrong precinct, oftentimes if they get really tired, they'll just give you a provisional ballot, which then won't be counted because you were in the wrong precinct, rather than trying to figure out what your precinct is. So a longer voting period might be superior to, picking like the first Tuesday after the first Monday and calling it vote day and letting everybody just go away for the day.
Okay, one more plus one more.
I thought this was maybe a thought you could leave us with. So a lot of predictions are that the election coming up is going to be very close. And you read sort of these scary things about the election being stolen. Is there anything you can say that would make us not be so fearful? I mean, are there any trends that suggest justice will be done whichever way?
Well, one thing is the greatly maligned Electoral College is going to solve some of this problem, because the likelihood of the election being close in enough states that the margin of Electoral College votes will be in play is much lower than the likelihood that nationwide the number of ballots cast in different places would be. Because I think we have, I'm going to get this number wrong, I think, but I think there are something like 80,000 precincts in the United States, or it's like some huge number, right? And so if you had to worry about the vote nationwide, you might be much more worried about this. But, who knows? Who knows? I mean,
It could be a lot worse.
oh, it could always be a lot worse, right? I mean, this is life, right? Life could always be worse. I'm generally, there aren't a lot of elections in which the margin of victory is smaller than the margin of error, right? Florida in 2000 was a really bad example of this. New Mexico, which people didn't focus on nearly so much, is an example of this. And if you talked to people a year ago, they were all predicting New Mexico was going to be a disaster because its election administration has some problems, and it was a state that was thought to be very much a toss-up. Now it doesn't look quite as much like a toss-up state, so even if things go a little bit wrong, it'll be good enough for government work. the thing that worries me being in California is we have some propositions on the ballot on which things are going to be very close, and that's just pure popular vote. And so the question of if people were denied the right to vote, or if provisional ballots went wrong, if proposition, if Section 203 foreign language ballot jurisdictions go bad, what happens with the absentee votes. So that worries me a lot more in a sense than the national election. But I could be terribly wrong about that. I don't have, there's that line of Yogi Berra's about the thing about the future is it's so hard to predict. And that's kind of how I feel about that.
So 2 thoughts on closing. One is get to the polls and vote and see if we can solve
Vote
this
early,
problem.
if not often.
Yes. And Pam, thanks very much.
Thank you. Oh my God, it's the liberal hero. The great liberal hero is here. Do you all know that the great liberal hero is here?
You students are very lucky. You should thank Professor Schroeder. She's brilliant. I'm just a lowly district court judge from Iowa.
He is not a lowly district court judge. He is the judge in Gall against United States.
They've never heard of it.
Yeah. Who has not heard of Gall? Oh, okay, well, Gall against the United States, this is the judge who said, if the sentencing guidelines are just guidelines, and this guy has put his life together, I'm not going to sentence him to spend a huge number of years in jail for a crime he committed when he was really young and he's put his life back together. And the Supreme Court finally said, yeah, that's exactly right. The guidelines are guidelines, so federal district judges can use some judgment and some compassion in sentencing.
I deserve equal time, but she won't tell you this, that but for her